My ultimate goal is to get out from underneath the authority of the federal government as a federal citizen. Not only because it's charging me income tax, because it is unlawful to do anything that is motivated exclusively to avoid paying income taxes. Tax evasion is unlawful, tax avoidance is not. But much more so, a substantial percentage of my taxes, income tax or otherwise, is going to the military-industrial complex, is going to Israel, is going to the big pharmaceutical companies. It is being used to support the endeavors of the elite of this country who are destroying the culture and the people of this country. So I don't want to give a dime to them if I don't have to. Citizen of the United States and citizen of the United States. Is there any difference between these two phrases as they are presented? Open question. Doesn't look like there's much. No, in one case the C is capitalized, in the other case the C is not capitalized. Big deal. Unfortunately, or fortunately, depending on what kind of lawyer you are, there's a huge difference. No person, this is part of the Constitution, not one of the amendments, but of the Constitution. No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President. In both cases, the C is capitalized, and in both cases the C has a substantially different meaning than citizen of the United States in the 14th Amendment. In the case of the capitalized citizen, we are talking about a citizen of one of these states of the United States, and by virtue of being a state citizen, that individual is by derivation also a citizen of the United States. So when you see citizen of the United States, you're basically looking at a state citizen who by virtue of being a citizen of one of the states is also a citizen of the United States. Other portions of the Constitution, the qualifications for a senator shall not have attained, a senator must have attained the age of 30 years and been 9 years a citizen of the United States, and shall not, when elected, be an inhabitant of that state for which he shall be chosen. Basically, the person has to be a citizen of the United States for 9 years before he can be elected to a senatorial position of the United States. Now, at the very beginning, that wouldn't make any sense, would it? How could you be a citizen of the United States for 9 years if the United States had not been in existence for 9 years? Well, the obvious inference, and Judge De La Guerra explained, and very nicely in fact, explained what citizen of the United States means in this early context. And what it means is that the individual must have been a citizen of one of the states of the United States when the Union was formed, and must have been a citizen of that state for 9 years before being elected. In other words, again, citizen of the United States is a derivative role, and the primary role is being a citizen of the state of the United States. Likewise, representative could not have been a citizen of the United States for 5 years if the United States had not been in existence for 5 years. So again, citizen of the United States is a derivative role dependent on having been a citizen of one of the states combined to form the United States.
And an inhabitant as opposed to citizen. An inhabitant is...
Yes, and I cannot tell you, well,
because she could be a citizen.
when the Constitution was written, the problems that occurred in 1860 to 1930 were not in the minds of the people who were writing it. They wrote as carefully as they could, and they did a very good job. To my thinking, they only screwed up once in terms of their intent. And their intent was to create an apartheid situation, and they did. So I'm not calling that a screw-up. The citizens of each state shall be entitled to all privileges and immunities of citizens of the several states. This is also part of the organic constitution. And again, the word citizens is capitalized, indicating a very specific relationship between the citizen of one state and that citizen when he or she moves to another state. They are guaranteed the same privileges and immunities, and the privileges and immunities clause implies the Bill of Rights, the first 10 amendments of the Constitution. The judicial power shall extend to this is the defining of the role of the Article 3 courts of the United States. And their role will apply to controversies between two or more of the states, quite obviously. We're talking about interstate commerce, between a state and citizens of a different state, between two or more citizens of different states, and between citizens of the same state claiming lands under grants of different states. In other words, they may be from the same state, but the bone of contention involves different states and possibly different citizens of different states. I'm pointing this out because this is the judicial role of the government of the United States as it applies to state citizens. A very specific jurisdiction. It is the jurisdiction of substance that is very carefully defined. For example, in a tax court, if a case was brought before a tax court and it didn't involve taxes, then the tax court would have no jurisdiction over that. It would not have jurisdiction of subject. This is granting the federal government, the government of the United States, jurisdiction of controversies between citizens of different states and derivatives of that category. This is the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce. The rest of that is almost irrelevant. What I want to point out is that in other sections of the Constitution, it is spoken of jurisdiction there, the United States managing their jurisdiction over states. In other words, the United States is a plural entity, which makes sense because in that sense the United States is the union of X number of states united under the Constitution. For the very first time, the number of states is avoided in the phrasing of a constitutional amendment, and I will tell you that it has very good reason for this. None of the sovereign states wanted the responsibility of granting state citizenship to the slaves that had been freed. Very few of the states wanted them in their sovereign territory, and none of them wanted to grant them state citizenship. The only way this amendment was passed was by having the federal militia occupy the legislatures of 6 southern states to encourage the legislatures to pass the amendment. Moreover, in at least 3 other states, and I don't know if those were northern states or southern states, I'm sorry, but in at least 3 other cases, the state legislatures first voted in one direction to, with regard to the passage of the amendment, and then changed their mind and voted in the other direction. In some cases I think they voted for and then subsequently against, and then in another case I think they voted against and subsequently for. But in a very real sense it doesn't matter. We're looking at the approval of an amendment the likes of which would never pass judicial muster if you could get this into an appellate court or a Supreme Court that was honest. This amendment was never legitimately passed. I don't care about that reality at this moment. What I want to point out is that the description of the citizens of the United States, in this context, you don't know whether they are talking about a plural United States, such as a union of X number of sovereign states, or are they talking about a different meaning of the phrase United States? It took a couple centuries later for the Supreme Court to definitively say that the phrase United States has 3 separate and distinct meanings. The first meaning of the United States is that sovereign nation that exists among the community of nations of the world. So it's looking out at the rest of the world and saying the term United States refers to that nation that speaks for, represents, taxes sometimes, the population of the United States. That's the first definition. The second definition is that entity that exercises governmental authority over a specific territory. And that specific territory is the District of Columbia and territories and possessions of the United States. This was the fundamental weakness of the framers of the Constitution. Unwittingly, they created 2 entities that were legitimately called the United States. The first entity was the union of X number of sovereign states united under the Constitution of the United States. The second entity was that municipal government, and I use the word municipal intentionally, is that municipal government whose sovereignty, very important word here, whose sovereignty extended over the 10 by 10 square mile area of the District of Columbia, the recognized territories of the United States, which at various times have included Puerto Rico, Hawaii, Alaska, the Northwest Territory, Guam, etc. The third entity is the United States as the union of X number of states united under the authorization and constraints of the Constitution. So 1 and 3, definitions 1 and 3, tend to look at the United States looking outward and looking inward toward the 50 states, or now 50 states, united in common defense under the Constitution. The middle one, the second one, is a separate governmental structure with its own jurisdiction of sovereignty, with the freedom to establish a judicial system totally independent of the Constitution. Constitutionally, the Article 3 courts, the courts of the United States that are established by the Constitution, are required to function under common and equity law. But under the Article 1 courts that are established by Congress, they can function under any judicial system they want to, and in point of fact, they are currently functioning under what they call statutory jurisdiction, which means that the statutes of Congress that refer to the citizens of the United States, those are the statutory requirements that are imposed on the District of Columbia and the territories of Alaska and Hawaii, etc. No state shall make or enforce any law. The rest of this goes on to say that citizens of the United States are almost like state citizens, but they aren't. The citizens of the United States in the third sense of the definition are state citizens, just as George Washington and Benjamin Franklin and not only Abraham Lincoln, but Frederick Douglass, the guys who lived before the passing of the 14th Amendment. State citizenship preceded citizenship in the United States. After the 14th Amendment, a different kind, whether you want to call it a different class of citizenship, a different type of citizenship, the courts have recognized that citizenship at the national level is a different citizenship than citizenship at the state level. Each has its different citizens, its different privileges, its different immunities, and its different liabilities.
Oh, where's the number 2 one created? Where is that? Where it just says DC and the territories?
All three of those are definitions made by the Supreme Court about 1940. If you Google 3 definitions of United States and Supreme Court, you'll find it.
Okay.
A correct amendment to grant citizenship to the liberated slaves might have read, "No person born in any state of the Union," because we're not talking about naturalized slaves. None of the slaves were naturalized. Any person born in any state of the Union, as a matter of fact, you would probably want to import another or transported into any state of the Union in the state of bondage. You might not want to insert that clause. No person born in any state of the Union shall be denied citizenship in said state and in the United States by reason of race or previous condition of servitude. This amendment would not have created a different kind of citizenship. This amendment would have preserved the primacy of state citizenship and the derivative character of United States citizenship. When the lawyers used the wording of the 14th Amendment that they did, they intentionally created a new kind of citizenship. And the reason they did is they wanted, let's see if it's in the next slide. I'm going to say it, and then if it's in the next slide, I'll just pass over it. In the order of primacy, in the order of level of authority or significance, a sovereign, for example, a king, a queen, or the free citizens of the colonies after King George abolished their charters. A sovereign is above the government. This is recognized by state courts and the Supreme Court. They recognize that the people are sovereign. And if they create a government, the people are sovereign, and they delegate certain rights to the government, but they do not lose those rights in the process of delegating them. However, a government is above its citizens. Citizens are office holders of any government. Sorry to tell you that, but if you are a citizen of the United States, you are an office holder. Gotta look that up. You are one of the lowest orders of office holder, but citizen is an office in a government. I've already said that U.S. citizen used to exist only in a derivative sense. None of the states wanted to confer state citizenship on freed slaves. The feds, the lawyers created a primary citizenship in the United States. And when you read the IRS code, not when you read the IRS 1040 instruction, but when you read the IR code, you find out that a state is defined as, in some cases, the District of Columbia, in some cases, the District of Columbia and Territories, in other cases, the District of Columbia and Puerto Rico and Guam. The word state is never defined as one of the 50 states.
In the IRS code.
In the IRS code. If and when the code wants to specify the United States as the collective of 50 states, it will say the several states or the 50 states in Congress assembled. They will specify that they are thinking about a plural number of sovereign states. It's really fascinating. I don't think I included this data in another place, so I'll share it now. When you read the Internal Revenue Code, by common law, a law has to be understandable to a person of normal intelligence and literacy, or it is null and void for vagueness, or null and void for incomprehensibility. That's common law. The Internal Revenue Code, and the person who wrote the article from which I am quoting that, was writing at a senior level and high school level. It was not simplistic at all. It was relatively easy to follow. And there is a way of grading the difficulty of the literature. Newspapers are graded somewhere around a level of 6 or 7. The article that I'm quoting was rated at a level of about 10. Most of the Internal Revenue Code is at a level of about 30, and some of the more complicated sections are rated at a level of 50. So that it is not an accident, or you're not being particularly stupid when you can't make sense out of the Internal Revenue Code. It is intended that you not make sense out of it. Now, I have not read this anywhere, but I will tell you my impression. The reason it is intended to be incomprehensible is so that you are dependent on the Internal Revenue Service for interpreting it, at which point you become dependent on their interpretation rather than you're applying an interpretation that is consistent with regular literacy and the regular use of the English language. It is perfectly intentional, in my opinion, that the Internal Revenue Code is incomprehensible. The 13th Amendment says that neither slavery nor involuntary service. Now I want you to notice, and this is especially important in the 20th and 21st century, slavery has not been abolished. It has simply been moved to the prison system. But, and I didn't know where I had this in the presentation, in the 13th Amendment, The United States are plural. The convicts can be used for slave labor if they are duly convicted, and let's start at the beginning. Neither slavery nor involuntary servitude will be permitted except as punishment for crime whereof the party shall have been duly convicted. Slavery shall not exist within the United States or any place subject to their jurisdiction. Not its jurisdiction, if we were talking about the second definition of the United States, but their jurisdiction, the collective of the states united. Because when you're talking about the collective of the states united, we're talking about all of the X number of states united under. So you want to abolish slavery in all of the state jurisdictions. That clarity of plurality is totally absent in the 14th Amendment. Subject to the jurisdiction thereof, the lawyers intentionally made it ambiguous. I've already gone over that. If you have questions, please raise them. Both federal and state courts recognize the difference in the classes or types of citizenship, and it has been the only type of citizenship that appears no longer to exist is that derivative type of United States citizenship. That is the kind of citizenship that Frederick Douglass and Abraham Lincoln and George Washington enjoyed as derivative citizenship in the United States. That form of citizenship no longer exists. You are either a state citizen without citizenship in the United States, or you are a citizen of the municipal government of the United States. Sorry to tell you that. Because by virtue of being a federal citizen, your rights and immunities are granted to you by Congress, not by the Constitution.
Now, didn't you say once, though, that maybe it was the original 13 states were considered states, and all of the other entities that have been accepted as states in the United States are really territories because their admission was written a different way?
Their admission, it was not the intention of the people who brought the states in. Now, up until 1860. Up until 1860, the incorporation of any state into the Union, they were brought in with the same responsibilities and privileges of every other of the original states. After about 1865, because there's a question about the very legitimacy of the federal government today, there is at least some legal wrangling over whether the remainder of the states that have been incorporated since the Civil War, or whether they are merely states in waiting. But whether you will ever get that, right now we are living in such a kabuki theater that you cannot tell the players without a scorecard. And the federal government is happy to have the American public with blinders on their eyes, because then they'll follow them where they want them to go. I hope that answers your question. Do you want to rephrase it? If it doesn't, and I'll see if I can.
I guess I was thinking maybe that the states that have been admitted since whatever the date was, 1865, were still regarded as territories. And in which case, that one statement was, you're a citizen of the United States if you are an inhabitant of Washington, D.C., or the territories. And I didn't know if the newly admitted states were classified as the territories under that statement. But you're saying no.
I haven't addressed that question directly, Dawn. My impression, and that's all it is at this point in time, is that there was much more concern about bringing the slaves in as federal citizens than there was for guaranteeing the legitimacy of future states. But that's only an impression. There was so much manipulation of the legalities of the federal government at the end of the Civil War that reconstructing a chain of legitimacy, probably impossible. I think if we were to get, I think constitutional convention at this point in time would be absolutely disastrous, because the first thing they would do is throw out the Bill of Rights. But it would be possible to very carefully walk backward and grant pardons and immunities and annulments sequentially to a number of sections to reestablish a legitimate government. But it would have to be very carefully done, because right now we really do have a kabuki theater. The very fact that Congress acts as the legislative body for the federal United States, that is, the state government of the District of Columbia and territories and possessions. It acts as the legislature for that entity, and it acts as the legislature for the United States united under the Constitution. So they simply wear different hats. And one of the things that would be very useful in terms of the Internal Revenue Code, you'll never get it. It would be very useful for any section of the Internal Revenue Code if there was some place in the code that would tell you in what territory this applied. You know, whether you were talking about a law that applies to the 50 states, or are you talking about a law that applies to the citizens of the District of Columbia? You're not going to get that, because by law, the citizens of the District of Columbia need to pay income tax. By law, the state citizens do not. So the vast majority of taxpayers in the United States today have volunteered to be federal citizens. They have surrendered their state citizenship, at least their sovereignty of their state citizenship. I should specify it that way. They're still citizens of the state, but they've turned it upside down. Their primary citizenship now, by virtue of the elections that they have made, their primary citizenship now is to the federal government. And only their secondary citizenship is to the individual states of the Union. They have exactly inverted the level of significance and primacy of that citizenship. And we've done it. We've done it out of ignorance, but we've done it. I've gone over this, the lawyer's discovery of a second entity which could legitimately be called the United States. As I told Catherine, it was the second of three definitions given by the Supreme Court about 1940. I apologize for not having the exact date. And that second entity was the watershed for all kinds of mischief and fraud. The President of the United States has the power to appoint a chief executive for this municipal United States. And Congress is free to establish a court system theoretically unhampered by the Article 3 constraints of the Constitution. Article 1 courts, that is, courts established by Congress, are free to function under any jurisdiction, and by Congress, by congressional edict, they function under statutory jurisdiction. Whereas Article 3 courts are compelled, theoretically, this is not entirely the case nowadays, but theoretically are compelled to operate under law, that is what is known as common law. the municipal United States was free to borrow money as credit between 1871 and 1912. When they borrowed credit, they agreed to terms that required repayment of that loan in gold. Absolute idiocy. Perhaps they were bribed to do so, but that put an entity called the United States in hock to foreign bankers. And they were able to get the people of the United States to adopt that debt, even though it was only the federal entity that was responsible for that debt. There's a special word for that besides fraud, and the word, when you get John Jones to accept the debt of a legal fiction called John Jones, you have successfully gotten the living John Jones to pay a debt that he didn't know. That's exactly what happened in 1912. I've mentioned state citizens are sovereigns, and sovereigns are over the government, and citizens are basically employees and officers of the government. Something that is part of the IRS Secrets is that none of the Internal Revenue Code has the force of law. The IRS Code, the IR Code, specifies the terms of contract that a federal citizen has entered into with the federal government through the Internal Revenue Service. Now, you didn't know you were entering into a contract, but you were. When you applied for a Social Security card, when you applied for a bank account that was federally deposit insurance protected, let's see. Oh. When you applied for any of the federal benefits, you applied to become a federal citizen. Not because you did so knowingly, but because statutory law allows bondage by contract even without your being fully notified and aware of the contractual relationship. That is called colorable. Colorable means it appears to be something but isn't. When you have contracted with the federal government, you did not know you were contracting with the federal government. When you use this as money, you don't know it, but you're not using money. You're using a substitute for money. This does not have any intrinsic value. And by definition, real money has intrinsic value. I barter with Catherine. She has a table that she is willing to part with, and I have a television set that I'm willing to part. Barter is a form of money because it has intrinsic value. A gold coin has intrinsic value. A painting by Degas has intrinsic value. This does not. I do not pay debts with this. By the way, anytime you give this in exchange, you are not paying a debt. You are discharging a debt. And the difference is that this money is colorable. It looks like money, but it ain't. The contract in which you engaged didn't look like a contract, so you accepted it as you accepted it without knowing that you were accepting a contract. You in snooker. Me too. Last but not, let's see, when reading the IRS code or when reading the 1040 instructions, the suspicion becomes very strong. If you read it with a dictionary, and especially if you read it with a law dictionary, you get the impression that it is intended to be obfuscating. This is especially true with familiar words like state, United States resident, income. By the way, wages legally are not income, which is why you won't find there, it's either income or wages that is not defined, because wages is a fair and legal exchange of your labor for money. That's not income. Income, whether by definition or not, by common law, income is over and above an equal exchange. If it has taken me, the best way to describe it is this. Profit is my payment for having the industry to make a product. But rent is whatever I gain by simply owning a property and putting it up for use. One is earned, the profit is earned, but the rent is unearned. It's presumed that you have that property not by the dint of your own labor. It's presumed that your great-grandfather stole it from the American Indian, and therefore you have the property. So unearned income is taxable in theory. But the IRS is absolutely superb at misdefining, especially the familiar words. You want to read the IRS code with a dictionary in front of you, otherwise you're going to wind up saying, you're going to agree to something that you didn't want to agree to. Let's see what's on the next slide. I've mentioned this. State includes the District of Columbia, Puerto Rico, and Guam. It does not mean the 50 states united under the Constitution unless specifically indicated. And one of the rules that you need to remember, includes and excludes are restrictive in their function. For example, if you read a definition that says the word state includes the District of Columbia, Puerto Rico, and Guam, that is restrictive. It is saying that the state means, the word state means those three entities. You get what I mean? It could as easily said, state means District of Columbia, Puerto Rico, Guam, and no others. That's what I mean by being restrictive. Likewise, the word excludes is restrictive. If you have a group of fruit and I want to describe a subset of that fruit, I can say all the types of fruit listed here excluding apples. And therefore I have included every other kind of fruit except apples. By restricting, you're saying that there are no others excluded. Or if you're saying include, there are no other entities included in that subject. For example, in the first example, there are no other states other than the District of Columbia, Puerto Rico, and Guam. The wording and phrasing of IRS forms is intentionally leading one into accepting federal jurisdiction. I found this out partly because of my, let's see, is there a way of going backwards on this? There has to be. Yeah. There are two forms that when I am listed as a non-resident alien, I will probably still be filling out for the IRS. Each of those two forms has a pledge that I am not committing perjury. The exact phrasing of that pledge, as it is written, however, implies that I am a resident of the United States, even though I have declared myself to be a non-resident alien. How they do that is the exact wording. And the exact wording that is provided on the IRS form implies that you are within the federal zone, whereas the very form is going to be filled out by someone who claims not to be in the federal zone. As clear a case of misdirection as you can find. Those two forms, by the way, are the 1040NR and the W8, for those of you who happen to pursue this. I've listed here the number of services that the United States provides, whereby, by accepting these services, you volunteer to become a federal citizen. Not if you accept mail with a zip code, but if you send out mail with your zip code on it. If you open a checking account or bank or savings account that is FDIC protected. If you register to vote, you are volunteering to be a federal citizen. What's very interesting is a sovereign state citizen is not yet permitted to vote in a state election. There are people working to change that, but federal citizens can vote in state elections and sovereign state citizens cannot yet do so. And a sovereign state citizen, the role is reversed somewhat, but I can't recall the details, for running for Senate or representative. There is something that is absolutely absurd with respect to the logic of language, but I cannot dredge it up.
So do you always write Iowa out on your mail? What's the difference between IA and Iowa to anybody?
The difference is when you write IA, you are accepting federal citizenship. When you write out Iowa, you are declaring state citizenship.
And what's the postal code?
Zip code, the first digit in a zip code declares that location to be within a specific federal postal zone. So you are accepting living in a specific federal zone, namely a specific federal postal zone. And by accepting living in a federal postal zone, you are volunteering to be a federal citizen.
And what is the postal code? Then the remaining 4 digits without the first one?
The way around that, we have been taught to put the city, the state, and the zip code all on the same line, right? If you put the city and the zip code on one line and the state spelled out, Iowa, on the last line, you won't fall into that trap. For example, Iowa City 52240, next line Iowa, I-O-W-A, you will not be endorsing your federal citizenship. But the way you have been taught to do it is endorsing federal citizenship. And if it doesn't make any sense, you're right.
How did you find this out?
Reading.
Wow.
Reading places where they don't want you to read. No, I'm serious about it. They don't want citizens to understand this. They want citizens to be sheep going in that direction. Or if they change their mind, going in that direction. All of this is available, but you do have to go hunting for it.
But no lawyer in Iowa knows this.
They may know it, but they are members of the bar, which means that they are members of a club. And that club is not, the primary loyalty of a lawyer is to the court, to the citizenry, and last and least to his client. And the client, remember, is mentally incapable of coping with his legal situation.
Be interesting if you put everything as Iowa and then, you know, you die and they come in and say, okay, you owe federal estate tax, and you say, well, you know, I'm really just a citizen of Iowa. I mean, you know, they came into your spouse.
If you follow the correct procedures for removing yourself from the roles of being a federal citizen, and there are a number by which you have to, you know, it's not a simple process to say, I only want to be a state citizen. But if you go through it, they have no claim. They literally have no claim.
Do you know if anybody's ever tried it?
Oh yeah, I know for a fact that there are the number of people who are sovereign state citizens. That remind me to say something about sovereign citizen. But the number of sovereign citizens is very large, but you don't hear about them because you're not supposed to hear about them. Now, the thing that I wanted, even if you go down this road, which I plan on going down, I want to stress, never refer to yourself as a sovereign citizen. For two reasons. The most important reason being that all federal personnel, especially federal marshals, FBI agents, etc., are taught to think of sovereign citizens as domestic terrorists. I'm serious. I'm very serious on that. They are taught to think of you as the guy that's going to have a load of buckshot waiting for the U.S. Marshal. So even if you consider yourself a sovereign citizen, don't call yourself that. Now, you do have a reasonable way of protecting yourself, because in all of these occasions, you have unwittingly entered into a contract, haven't you? You have entered into a contract because the contract was not explained to you clearly with respect to your responsibilities, etc., etc., etc. That is lawful according to statutory law as it is exercised in the United States today. But if you knowledgeably understand that you have recourse, you can say, without prejudice, I employ the Universal Commercial Code, Section 1-308. This is saying that this section of the Universal Commercial Code allows me to reclaim my common law rights and privileges that otherwise I surrendered under statutory law. And it's very important. Now, you still have to go through the monkey shines of officially abandoning this role and officially abandoning that role and officially abandoning a multitude of roles. But when you tell the federal government, I was not appropriately informed of this contract and therefore the contract is null and void, at least in theory, and I'm confident in a number of cases it does in fact work, you will be honored in that annulment of the contract.
So when would you use this?
On every check that I am writing nowadays, I'm putting it at the bottom of my check. When I send a letter to the Secretary of the Treasury annulling my volunteering to be a federal taxpayer, I'm going to stamp that at the bottom underneath my signature. On any official document, including a check, I would put that.
And have you ever had anybody question you, like when you send in a check?
Not yet.
So you're an experiment right now. You're trying to do this.
I've stamped this on all of my extant checks now.
And where did you order
stamp
that
it?
stamp?
Right? Actually, because my stamp is 2 lines, I stamp it so that the without prejudice is right above the signature line and the UCC 1-308 is right below the signature line. And so when I sign it, I'll sign it above the without prejudice. And here, with respect to my driver's license, I'll show you what I've done. Because you need to, if you want to exempt yourself from the buckle your seatbelt law, you need to do something like this. Write by your signature without prejudice, UCC 1-30. If you want to put that in front of the camera, go ahead. I've already put that on my passport, because right now my passport identifies me as a U.S. citizen. And since I am in the process of becoming a sovereign of the state of Iowa, go ahead.
Where did you order your stamp?
I went online, and it's easy. There
Can
are
you just
a
say
number of...
any, well, there are a lot of places that
But you
sell
wrote
rubber
that.
stamps.
Yeah, on that I happen to write it, because the stamp wouldn't fit.
Could you go in and ask, you couldn't go in and ask for a driver's license with that put on it?
No,
And the
no
same
state
with,
official is going to honor that.
and same with the passport, so,
Well, I have done it. Remember, intent is 90% of the law. Whether that applies to a law that the Congress passes, whether it applies to an amendment, or whether it applies to what I do on the form. And as long as my intent is to claim my constitutional rights, that intent is perfectly clear. Now, can they ignore it? Of course they can. But not if they want to pretend that they are observing the rule of law.
So you wouldn't file your income tax automatically? You would write out, you would have your papers printed out and then add that to where you sign
No,
your...
in terms of income tax, I'm planning on sending a letter to the 2 commissioners of the IRS and to the Secretary of the Treasury, indicating that I am voluntarily revocating my election to be treated as a resident of the United States.
So you're not gonna pay this, you're gonna see how it goes?
Hmm? And a lot of people have done this, but you're not supposed to know about it.
and what happens to them?
The reports that I am getting is that they are quietly living their lives as state citizens.
So you're only doing this with the federal government, not with the state. You're gonna pay
Well,
state
the-
income taxes.
Well, yeah, I'll wind up paying state income tax. I don't have a problem with that. State income tax, although the state sends too damn much money to the federal government, a substantially greater portion of state tax goes to worthwhile state projects, not to Boeing or Lockheed. Now, okay, I'll take the time. There are 3 or 4 websites that you want to become familiar with, and I'll say them clearly and slowly. Weiss Paris, W-E-I-S-S Paris, Paris.com, is an agency located in Europe that is specifically providing guidance and information for legal methods of not paying income tax by virtue of not being under the jurisdiction of the Internal Revenue Service. Now, I'm saying that very carefully because I don't plan on utilizing their services. Their services, at the most basic level, are something like $1,200. One of my friends said, hey, it's worth it. But I plan on understanding the law well enough to do it otherwise. But the nice thing about weissparis.com is that they have a lot of informational resources that you'll want to make use of, even if you don't make use of their services. Another website is 1215.org. Nice guy, I don't recall what his name is, but very intelligent, and gives you a lot of information on learning both about the law and learning about how to deal with the IRS.
That's Bill Thornton. And one thing, Bill Thornton, and one thing he says is refer to yourself as a people.
Yes,
Don't
absolutely.
even go to the
You are not a
person.
person, you are a people.
Because in every constitution, state and federal, the sovereignty lies with we the people.
Exactly. In fact, one of the other websites logically arrived at the conclusion that Mr. Brushaber of New York would legitimately be called a non-resident non-person, but the Supreme Court called him a non-resident alien. Now, he was born in the state of New York, and his domicile was in Brooklyn, and the Supreme Court called him a non-resident alien. By which definition, if Mr. Brushaber was a non-resident alien, so am I. But you cannot tell the IRS that. You've got to deal with them. You've got to learn enough of the IRS language and way of thinking to answer their complaints with law. Now, that's 1215. Another website is supremelaw.org. Also written by a very intelligent guy who's something of a pain in the butt. His attitude comes through, but he's very intelligent and he has a lot of useful information on his website. AnnaVonReitz.com. I've mentioned her before, but ANNAVONREITZ, either .com or I think it's .com, but it might be .org. Anna is a little kooky in several other areas, but she seems to be spot on in understanding how to deal with this kind of legal situation and how to basically extricate yourself from under the government that is trying to turn you into a serf. Those are the most important ones.
So what implication does it have for when you write this on a check and you send it into your utility company, you're paying your utility bill?
I don't think the utility company is going to know or care.
So who is going to know and care?
If you send it in to pay your property taxes, someone is going to notice that. If you have that stamped on your driver's license and get arrested for not buckling your seatbelt, the judge is going to know that the officer has to let you go.
And refresh my memory, what is UCC 1308? What?
That is the section of the Universal Commercial Code that allows you to reclaim your constitutional rights which you unwittingly surrendered.
Okay.
But no one should approach this relying on whatever I presented. I think that's obvious. Not because I'm incompetent, I'm not. But you will be quizzed by people who don't want the citizenry to employ and enjoy their rights and privileges.
Why would that even be in the UCC?
I'm sorry?
Why would this even be in the UCC, this provision to allow you to do it?
You were deprived of your constitutional rights when the type of law that was employed by the courts was changed. That was a deprivation of your rights, and that new form of law had to provide a remedy for the defect that they had built into the law.
I see.
If you create a problem, you have to provide a solution for the problem. And when they changed the jurisdiction of the law, they needed to provide a remedy for that change. One of the nice things about this 1-308 is it allows you to be selective in those situations where you want to be a citizen of X, Y, or Z, and those situations in which you reject that citizenship.
Now, does it have to be in all caps? You keep putting it in all caps.
No. Oddly enough, simply the expression, you could probably misspell it. And just approximate the legibility of it, because it is the intention to employ the statute rather than the exact wording that is crucial there. That's gotta be it, because I didn't have the energy to go any further than that. Without looking for sympathy, I have paid my dues to Montezuma.
That's fine.
And we didn't need any sound.
Yeah.
That is so much to think about. So
Those
did all
four
this happen,
websites,
did this all happen in 1940 with the Supreme Court decision?
No, it started in 1868. It went through several progressive steps up to 1912, went through some other steps in 1917, and probably reached its climax in 1938. In 1938, the Supreme Court officially recognized statutory law as the first level of law, even in Article III courts. So getting something passed, I'll give you an example of how deceptive it can be. The courts that are called the District Courts of the United States, those courts are Article III courts. But Congress has set up other courts, the titles of which are the United States District Court. Those are Article I statutory courts. And if this makes sense to you, you need to see a psychiatrist.
What are Iowa district courts?
Iowa district courts are state courts.